Question 1. An Indiana Notary Public's commission is valid for a term of how many years? A. 4 years. B. 5 years. C. 8 years. D. 10 years. Answer: C. 8 years. An Indiana Notary Public's commission is issued for a term of 8 years, beginning on the date specified in the Notary Public Commission. This is a longer term compared to many other states, making it a critical piece of information to remember for the exam. For example, if your commission is issued on July 1, 2025, it will expire on June 30, 2033. Think of the number 8 as a key figure in Indiana notary law, as it sets the timeline for your entire service period before you must renew. Question 2. When performing a jurat, what action is required of the notary that is not required for an acknowledgement? A. The notary must witness the signer signing the document. B. The notary must administer an oath or affirmation to the signer. C. The notary must verify the signer's age. D. The notary must place their seal on the document. Answer: B. The notary must administer an oath or affirmation to the signer. The core purpose of a jurat is for the signer to swear or affirm that the contents of the document they are signing are true. This requires the notary to administer an oath, such as, "Do you swear under penalty of perjury that the statements in this document are true," which is not a component of an acknowledgement. While witnessing the signature is also part of a jurat, the defining act is administering this sworn statement. Remember, the word jurat is related to jury and jurisdiction, all of which involve sworn truth. Question 3. What is the maximum fee an Indiana Notary Public may charge for an individual notarial act? A. $5. B. $10. C. $15. D. A reasonable amount determined by the notary. Answer: B. $10. Indiana law sets a specific cap on the fees a notary can charge, which is currently $10 per notarial act. This fee is for the notarization itself and does not include other potential charges like travel fees, which must be agreed upon separately and in advance with the signer. For example, if a client has 2 separate documents that each require an acknowledgement, the notary can charge a maximum of $20, $10 for each act. Always be sure to inform the signer of the fee before performing the service to maintain transparency. Question 4. Which of the following details is not a required element on an Indiana notary's official seal? A. The words, Notary Public. B. The words, State of Indiana. C. The notary's commission expiration date. D. The notary's commission number. Answer: D. The notary's commission number. Indiana law specifies exactly what must appear on a notary's official seal, which includes the words, Notary Public, State of Indiana, seal, and the notary's name as it appears on the commission. While the commission expiration date must be part of the complete notarial act, it is not required to be on the seal itself. A good tip is to visualize the essential information needed to verify your status on the spot. Your name, title, and state jurisdiction are key, but the specific commission number is not. Question 5. An Indiana notary who wishes to perform remote online notarizations, RON, must first register with the Secretary of State and A. Purchase an additional $50,000 surety bond. B. Pass a specialized technology proficiency exam. C. Select a state-approved RON technology provider. D. Work exclusively for a title company. Answer: C. Select a state-approved RON technology provider. To legally perform remote online notarizations in Indiana, a commissioned notary must contract with a technology vendor whose platform meets the state-specific security and procedural requirements. The Indiana Secretary of State maintains a list of these approved providers, and the notary must identify their chosen provider as part of the RON application process. This ensures that all remote notarizations are conducted using secure, compliant software for identity verification and record keeping. Think of the RON provider as your digital office. It must meet the state's building codes before you can operate there. Question 6. A notary public is asked to notarize a document for a family member. Under what circumstance is this permissible in Indiana? A. It is always permissible. B. Only if the family member is immediate, such as a spouse or child. C. Only if the notary has no direct beneficial or financial interest in the document. D. It is never permissible to notarize for a family member. Answer: C. Only if the notary has no direct beneficial or financial interest in the document. Indiana law prohibits a notary from notarizing a document if they are a party to it or have a direct financial or beneficial interest in the transaction. While there is no specific rule against notarizing for relatives, the key is the notary's interest. For instance, you could notarize a car title for your cousin buying a car from a third party, but you could not notarize the deed to a house that you are co-signing or inheriting. Always remember the core principle: a notary must be an impartial witness, and a personal stake in the outcome disqualifies you. Question 7. What is the minimum surety bond amount required for an Indiana notary public? A. $5,000. B. $10,000. C. $15,000. D. $25,000. Answer: D. $25,000. An applicant for an Indiana Notary Public Commission must obtain a surety bond in the amount of $25,000 for the 8-year term of the commission. This bond is not insurance for the notary, rather, it protects the public from financial harm resulting from the notary's misconduct or negligence. For instance, if a notary's error on a property deed causes a financial loss to someone, the bond could be used to cover those damages. It is a financial guarantee of the notary's faithful performance of their duties. Question 8. An Indiana notary moves to a new residential address within the same county. What action must the notary take? A. No action is required as long as they remain in the same county. B. Purchase a new surety bond. C. Notify the Indiana Secretary of State of the address change within 30 days. D. Surrender their commission and reapply. Answer: C. Notify the Indiana Secretary of State of the address change within 30 days. A notary public is required by law to keep their information current with the Secretary of State's office. If a notary changes their residential address, email address, or legal name, they must notify the state within 30 days of the change. This ensures that the state can maintain an accurate record and contact the notary if needed. A simple way to remember this is to treat your notary commission like your driver's license. You must always update your address with the official issuing authority. Question 9. In a notarial certificate, the statement, State of Indiana, County of Marion, is referred to as the A. Jurisdiction. B. Acknowledgement clause. C. Venue. D. Commission statement. Answer: C. Venue. The venue is the part of the notarial certificate that indicates the location, specifically the state and county, where the notarization took place. This is a critical element because it establishes that the notarial act was performed within the geographic boundaries of the notary's jurisdiction. For example, even if the document relates to property in Florida, if the signer appears before the notary in Marion County, Indiana, the venue must state State of Indiana, County of Marion. The venue answers the question, where did this happen? Question 10. For which of the following documents is an Indiana notary prohibited from making a certified copy? A. A personal letter. B. A power of attorney. C. A birth certificate. D. A college diploma. Answer: C. A birth certificate. Indiana notaries can certify copies of most documents, but they are strictly prohibited from certifying copies of publicly recordable documents, such as birth certificates, death certificates, or marriage licenses. Certified copies of these vital records can only be obtained from the official government agency that holds the original, like a county health department or state vital records office. A good rule of thumb is if a government office is the official keeper of the original document, you cannot certify a copy of it. Question 11. What is a key difference between an oath and an affirmation? A. An oath is written, while an affirmation is spoken. B. An affirmation is only used in court proceedings. C. An oath contains a reference to a higher power or deity, while an affirmation does not. D. An oath must be administered by a judge, while an affirmation can be administered by a notary. Answer: C. An oath contains a reference to a higher power or deity, while an affirmation does not. Both an oath and an affirmation are solemn promises of truthfulness, but they appeal to different authorities. An oath is a religious or sacred pledge, often ending with, "So help me God," while an affirmation is a secular promise made on one's personal honor, such as, "I solemnly affirm." A notary must offer the choice to the signer, as a person may have personal beliefs that preclude them from taking a religious oath. The legal effect of both is identical, breaking either promise constitutes perjury. Question 12. A signer appears before you with a document written in Spanish, a language you do not understand. The notarial certificate is in English. What should you do? A. Refuse the notarization because you cannot read the document. B. Proceed with the notarization as long as you can communicate with the signer. C. Require the signer to provide a certified English translation. D. Direct the signer to a notary who is fluent in Spanish. Answer: B. Proceed with the notarization as long as you can communicate with the signer. An Indiana notary's duty is to notarize the signature, not the contents of the document. Therefore, you are permitted to notarize a document in a foreign language as long as you can communicate with the signer to properly identify them and complete the notarial certificate, which must be in English. The key is ensuring the signer understands the purpose of the notarial act and can be identified according to state law. Your focus is on the signer and the notarial block, not on becoming an expert translator of the underlying document. Question 13. Which of the following is considered satisfactory evidence for identifying a signer in Indiana? A. A student ID card from a private university. B. A signed letter from the signer's employer. C. A current, government-issued identification card with a photograph and signature. D. The notary's personal belief that the person is who they claim to be without any other proof. Answer: C. A current, government-issued identification card with a photograph and signature. Indiana law defines satisfactory evidence for identifying a person as proper identification, personal knowledge, or a credible witness. Proper identification specifically refers to a current ID card or other document issued by a federal or state government that contains the person's photograph and signature. For example, a valid driver's license, state ID card, passport, or military ID would all qualify. The other options are not sufficient on their own because they lack the required government issuance and security features. Question 14. An individual must meet all of the following requirements to become a notary in Indiana except: A. Be at least 18 years of age. B. Be a citizen or legal resident of the United States. C. Be a registered voter in the state of Indiana. D. Reside or have a primary place of employment in Indiana. Answer: C. Be a registered voter in the state of Indiana. The eligibility requirements to become a notary in Indiana are clearly defined and include being at least 18, a U.S. citizen or legal resident, and residing or working primarily in Indiana. However, there is no requirement that an applicant must be a registered voter. This distinction is important because it ensures that the ability to serve as a public official is not tied to one's voting status. Always focus on the specific requirements listed in the state's notary handbook: age, residency/employment, and legal status in the U.S. Question 15. Are Indiana notaries required to maintain a journal of their notarial acts for traditional, in-person notarizations? A. Yes, a journal is mandatory for all notarial acts. B. No, a journal is not required but is considered a best practice. C. Only for real estate transactions. D. Only if the fee charged is more than $5. Answer: B. No, a journal is not required but is considered a best practice. Indiana law does not mandate that notaries maintain a journal for traditional, in-person notarizations, although it is required for remote online notarizations. Despite not being legally required for in-person acts, keeping a detailed journal is highly recommended as a best practice to protect the notary from liability. A journal serves as a reliable record of the notarizations performed, which can be invaluable evidence if an act is ever questioned or challenged in court. Think of a journal as your professional diary. It's not required by law, but it's the best way to remember and prove what you did. Question 16. A notary who resigns their commission must do which of the following with their official seal? A. Return it to the Secretary of State. B. Sell it to another commissioned notary. C. Keep it for personal records. D. Destroy or otherwise render it unusable. Answer: D. Destroy or otherwise render it unusable. To prevent fraudulent use, a notary whose commission has expired, been resigned, or revoked must destroy, deface, or otherwise damage their official seal so that it cannot be misused. The seal is a unique tool tied to a specific commission and cannot be transferred or retained for use after the commission ends. For example, one could use a hammer to smash a rubber stamp or scratch the surface of an embosser to permanently disable it. This final act of duty ensures the integrity of the notarial office. Question 17. Under what circumstances may an Indiana notary refuse to perform a notarial act? A. The notary disagrees with the contents of the document. B. The signer is not from the same county as the notary. C. The notary is not satisfied with the signer's identity. D. The signer cannot pay the maximum fee of $10. Answer: C. The notary is not satisfied with the signer's identity. A notary has the right and responsibility to refuse a notarization if they have a reasonable belief that the signer is not who they claim to be, is being coerced, or does not understand the document. Failing to properly identify the signer is a serious breach of duty, so if the provided ID is expired, looks altered, or the credible witness is not reliable, the notary must refuse the act. A notary cannot refuse service based on personal disagreement with the document's content, as their role is to be an impartial witness to the signing, not a judge of the transaction. Question 18. What is the primary purpose of a notarial certificate? A. To summarize the contents of the document being signed. B. To certify that the document's contents are true and correct. C. To describe and attest to the specific notarial act that was performed. D. To provide legal advice regarding the transaction. Answer: C. To describe and attest to the specific notarial act that was performed. The notarial certificate is a written statement, signed and sealed by the notary, that outlines the facts of the notarization. It specifies what happened, where it happened, when it happened, and who was involved, such as stating that the signer personally appeared and acknowledged their signature on a certain date. It is the notary's official testimony of the act, not a validation of the document's content or a legal opinion. Think of the certificate as the what, where, when, and who report of your official duty. Question 19. If a signer does not have an acceptable ID and is not personally known by the notary, they may be identified by a credible witness. A credible witness must: A. Sign an affidavit confirming the signer's identity. B. Be a family member of the signer. C. Personally know the signer and present the notary with proper identification. D. Be an attorney representing the signer. Answer: C. Personally know the signer and present the notary with proper identification. A credible witness acts as a human identifier when a signer lacks traditional ID. Under Indiana law, for a witness to be credible, they must personally know the signer, and the notary must be able to identify the witness through either personal knowledge or a proper government-issued ID card. For instance, if your neighbor, whom you know well, the credible witness, brings a friend, the signer, to you, your neighbor can vouch for their friend's identity. The key is establishing an unbroken chain of trust. You trust the witness, and the witness trusts the signer. Question 20. A notary who is acting as a notary signing agent, NSA, is a specialized notary who has been trained to A. Provide legal advice on loan agreements. B. Facilitate the signing of real estate and loan documents. C. Negotiate interest rates for mortgages. D. Issue title insurance policies. Answer: B. Facilitate the signing of real estate and loan documents. A notary signing agent is a notary public who has specialized knowledge to guide signers through a loan document package. NSAs are hired by mortgage, title, and escrow companies to ensure that real estate closing documents are executed correctly, notarized, and returned for processing. Their role is strictly to handle the signing and notarization process, not to provide legal advice or explain the terms of the loan. Think of an NSA as the impartial traffic controller for the paperwork at the final stage of a home loan transaction. Question 21. Before an Indiana Notary Commission can be issued or renewed, what educational requirement must the applicant fulfill? A. Obtain a degree in paralegal studies. B. Complete a state-approved education course and pass an examination. C. Attend a one-day seminar hosted by the county clerk. D. No education is required if the applicant has a clean record. Answer: B. Complete a state-approved education course and pass an examination. Indiana law mandates that all new and renewing notary applicants successfully complete a state-approved education course and pass an exam with a score of at least 80%. This requirement ensures that every notary understands the current laws, duties, and best practices associated with the office before they are authorized to act. This rule enhances professionalism and protects the public by making sure notaries are knowledgeable and competent. Completing the course and exam is a non-negotiable first step in the application or renewal process. Question 22. When notarizing a document, a notary may not A. Charge a fee for the notarial service. B. Complete the notarial certificate using information from the notarization. C. Leave the notarial certificate blank for the signer to fill in later. D. Keep a record of the notarization in a journal. Answer: C. Leave the notarial certificate blank for the signer to fill in later. A notary is solely responsible for completing the notarial certificate accurately and entirely at the time of the notarization. Leaving any part of the certificate blank, especially the date or venue, and allowing someone else to fill it in later is a serious violation of notarial duty that could facilitate fraud. The certificate is the notary's official statement of fact, and they must personally attest to all information within it. Always complete every part of the certificate yourself before applying your signature and seal. Question 23. A notary is presented with a document to notarize that contains several blank spaces within the main text. The notary should A. Fill in the blank spaces with "not applicable" before notarizing. B. Ask the signer to fill in the blank spaces before proceeding with the notarization. C. Notarize the document as is, since the notary is only concerned with the signature. D. Refuse to notarize until the signer can provide a completed document. Answer: B. Ask the signer to fill in the blank spaces before proceeding with the notarization. A notary should not notarize a document that contains blank spaces, as this creates an opportunity for fraudulent information to be added after the notarization is complete. The proper procedure is to ask the signer to either fill in the blanks or to line through them and initial the line. The notary's role is to be a gatekeeper against fraud, and ensuring the document is complete before notarizing the signature is a key part of that responsibility. Remember the tip, no blanks allowed, to protect both the signer and the integrity of the document. Question 24. A person's authority as a notary public to perform a remote online notarization, RON, ends when A. The notary moves to a new county within Indiana. B. The notary's chosen RON technology provider goes out of business. C. The notary's underlying traditional commission expires. D. The notary completes 100 remote notarizations. Answer: C. The notary's underlying traditional commission expires. The authorization to perform remote online notarizations is not a separate, standalone commission, it is an additional power granted to a traditionally commissioned notary public. Therefore, if the notary's traditional 8-year commission expires, is revoked, or is resigned, their ability to perform any notarial act, including remote ones, automatically terminates. To continue performing RONs, the notary must first successfully renew their traditional commission and then re-register for remote authorization. The traditional commission is the foundation upon which all other notarial powers are built. Question 25. An Indiana notary's signature on a notarial certificate must: A. Be an exact match to the signature on their driver's license. B. Be signed exactly as their name appears on their notary commission. C. Be signed with their full middle name, even if it's not on the commission. D. Be printed in block letters for clarity. Answer: B. Be signed exactly as their name appears on their notary commission. The signature of the notary public is a critical element of the notarial act and must be consistent with the name registered with the Secretary of State and printed on their commission. If a notary's commission is issued to Jane Doe, she must sign every notarization as Jane Doe. Using a different version, like J. Doe or Janie Doe, would invalidate the notarial act because it does not match the official record of her authority. A good habit is to practice signing your name exactly as it appears on your commission so it becomes second nature.